Stand by, we're about to begin. Good day and welcome to the Alston & Bird Navigating the California Consumer Privacy Act of 2018 webinar. Today's call is being recorded. At this time, I'd like to turn the conference over to Mr. Jim Harvey. Please go ahead, sir.
Thanks very much, and welcome everyone to our first webinar on the Consumer Privacy Act of 2018, passed in California earlier this summer, as I'm sure most of you are aware. We're glad that each of you is here today. I think it is a momentous event, as indicated by one statistic. This nearly triples prior attendance at any webinar that our firm has ever done. So there's a lot of interest in the statute, and obviously all of you are interested, and we're going to try and click through things very quickly. As you might imagine, there's a lot of ground to cover. Our speakers today are myself. I co-chair the privacy practice here at the firm with David Keating, who is another speaker, and both David and I are located here in the Atlanta office. I also co-chair our cybersecurity preparedness and response team with Kim Peretti, who's in our DC office. We're also glad to have with us today Peter Swire, who is senior counsel to our firm and a professor at the Georgia Tech College of Business, Scheller College of Business. And Peter is obviously one of the most well-known and long-time practitioners in this area. Among other things, he served as President Clinton's privacy czar. Those are my words. So we're pleased to have his insights with respect to the topic today. The agenda: we're going to talk about the CCPA and where it came from and where it's going to go. We're also going to give a substantive overview. We really focused on how to go about this. As many of you know, in connection with the GDPR, we had what we called the roadmap series to the GDPR, and that was, I think, probably 6 or 8 different webinars, and it was very useful. We rolled them out every 45 or 60 days. We may have that here, but today we're trying to give you a substantive overview. As a result of that, we're not going to focus much on specific industries, but hopefully give you the tools to go away and ask questions and get answers as efficiently as possible. We're also going to focus on what do you do first and how do you do it. Administratively, we will be giving CLE credit. At the contact the link that was provided to you to sign up if you don't get the CLE credit, and we have a great staff here that works on providing CLE credit in virtually every jurisdiction possible. Given the number of people on the presentation, we're not able to permit to take verbal questions, but please do ask questions via the Ask a Question box on the screen, and we'll take those where we can. We are going to be very pressed for time. We will distribute slides to the audience members. Sometimes the audio turns out well enough to distribute, and sometimes not, but if we can distribute it, we will. And finally, if you snuck through our filters and you are a member of the press, either directly or indirectly, all of these records are, all of these comments are off the record, not for attribution, and in fact, you should not be participating in this call in your capacity as a member of the press. So with that, I'm going to turn it over to Peter Swire.
Thanks, Jim, and hello to everybody. I'm going to speak give a few minutes of background about where this California law came from, what are likely developments in California before the effective date in early 2020, and the big question is whether Congress, the U.S. Congress, is going to step in to preempt. Where it came from is really led by this real estate businessman, Alistair McGirt. He wanted to give something back to the community after a successful world and business career, and he sure did. He spent 2 years preparing for the Ballot initiative, and a story of his background is available on a web link here. Part of what they did is focus groups about asking people what they felt about certain key privacy issues. One of them is that if you ask people, do you think you should know the data the companies hold about you, and you should be able to opt out, you get about 85 or 90% of people in the United States saying yes, they agree. So this is widely popular. And that helps explain why this wasn't GDPR for California. GDPR has a lot of opt-in, and Mr. McTaggart opposed opt-in. He wanted something that was simple to pass, which is basically know your data and get an answer. I'm just noting there was a question that came in about nonprofit entities. Nonprofit entities are not covered as a basic rule, and we'll be keeping an eye on other questions that get texted in as we go through the hour today. In politics, as in life, timing is everything. California, the rules are you need a little over 300,000 signatures to get a ballot initiative on the ballot. Are you for or against this ballot initiative? Cambridge Analytica and Facebook burst into the news while the signatures were being collected. They woke up a couple of weeks later with over 600,000 signatures, way more than they needed. And also Facebook, which had been funding opposition to the initiative, backed out and said, actually, they're going to go along with this. So there was a sort of political turning point in California. The initiative was going to be on the ballot this fall. It was probably going to pass, but Mr. McTaggart decided not to insist on his ballot initiative and instead negotiated inside the California legislature. There were reports that $100 million was going to be spent by industry opposing the ballot initiative, so who knows what money at that scale would do in politics. There was also reports that they were doing opposition research on Mr. McTaggart and his family. Politics is a contact sport. So for whatever reason, he decided to switch to the legislative track, and that meant that there's a possibility of amendments over time. You don't need a new ballot initiative. Instead, the California legislature, notably next year, could pass amendments. But the bill that was passed really was pretty much what McTaggart would agree to or not. If it wasn't strong enough in his view, he was going to keep the ballot initiative. So it was an unusual moment in privacy politics in the United States because the privacy side sort of held the keys to the kingdom here. They were going to win a strict rule unless something pretty strict got passed by the legislature. Now, as some of you have been seeing, the legislature did pass some so-called technical amendments just in the last 10 days or so. They're awaiting signature from Governor Jerry Brown and expected to sign it. These amendments were modest in scope, clarify how the medical and financial data laws fit together, HIPAA and Gramley-Spliley. There is a 6-month delay in enforcement from January 1st, a year from now, till 6 months later, unless the California Attorney General writes the rules quickly. So probably actual enforcement will be in the middle of 2020. And Alston has an advisory up of the other details of these recent changes. But the big action is going to be next year. So what's going to happen next year? The California legislature will come back into session in 2019. Usually they pass their major actions during the summer and early fall. And people expect big battles on this. Sacramento's going to be a busy place when it comes to privacy for next year. Overwhelmingly to date, the business lobbying has been on the issue of limiting the private right of action that's related to data breach. And David Keating and Jim will be talking more about these private rights of action today. If it's not a private right of action, if a company is found to violate the other parts of the law, the principal way to enforce that will be the Attorney General, who's getting a bunch of staffing and funding increases as part of the bill. And there may also be deceptive trade practice actions under the California law that requires economic harm, economic loss to bring the actions, but there will be enforcement that way. As the negotiations happened this year, the idea was to have technical changes to the California Privacy Act, but the scope may turn out to be greater than that, and there may be more pushback from industry saying everyone needs more time to comply with these changes. One of the big changes next year is that Jerry Brown's term ends this year, so there'll be a new governor in California who will either pass or sign or not sign the law. The new governor is expected to be Democrat Gavin Newsom, and Newsom is often thought to be closely aligned with Silicon Valley, so it's possible that compared to Jerry Brown, he'll be somewhat more flexible about having pro-information, pro-business amendments as next year goes forward. You might wonder how the privacy groups have been doing in lobbying on this. The answer is they've been thoroughly disorganized to date. Many of them have critiqued the privacy law because they think it's not strong enough, and they haven't shifted over to sort of preserving what the law currently says. So at least for right now, business is dominating the field when it comes to possible amendments in California. But nonetheless, this California privacy law, with all its requirements, is on the books, takes effect a year from January, and that's led to a sudden and quite remarkable interest in Washington, D.C. about maybe it's time to pass federal privacy legislation after all. The Trump administration, which in general has been very cautious about regulations, has been holding meetings on a number of privacy kind of topics. The Federal Trade Commission hearings are happening this fall on privacy, October 10th and 11th. I've been tentatively scheduled to testify on one of those. And that will be partly with attention to California and what the effects of California will be. And just this week, the U.S. Chamber of Commerce issued its new principles calling for federal privacy legislation nationwide, which is something the Chamber, to my knowledge, had never done in its history until just this week. The business concern, the sudden interest in federal law, is to stop the California law from taking effect, and maybe even more so, stopping other states, and Vermont seems to be on deck for possibly the next state, from passing laws. We've seen the patchwork of 50 state laws for data breach. Business doesn't want to deal with that for privacy legislation, but if California gets the ball rolling, we remember back in the early 2000s, California passed the first data breach law, and we all know what happened after that. So this slide talks about my skepticism about the chances for federal privacy legislation. I've worked around these issues for more than 20 years now, long experience, and I think it's way harder to pass federal privacy legislation than most people think. So I'm willing to go out there and say I think there's less than a 10% chance that it passes next year. And if it doesn't pass next year, then California goes into effect. Bob Gelman, who has also been in this space for a long time, has written a series of articles about the long road to privacy legislation. Here's part of why it's so darn hard to pass the law. One is that you probably have at least 3 House committees and 3 Senate committees who would have jurisdiction. And getting them to agree, especially in the first year of a complicated new bill, is extremely difficult. Another part is you've got HIPAA and Gramm-Leach-Bliley and a dozen other federal laws. Who's going to be stricter, who's going to be less strict? So the California law is stricter than Gramm-Leach-Bliley in a number of respects. For just ordinary business information, stricter than the federal law for banking information. So how are you going to sort out who gets treated more strictly, the banks or a regular business operation? Also, the FTC does not have general privacy powers. It can't apply to regulated industries. It doesn't apply to nonprofits, et cetera. So there's no agency sitting there really ready to do the whole job in Washington. That makes it hard. Some other things make it hard. Is President Trump going to put his weight behind signing a bill with mandatory privacy rules nationwide? That's very different from the way he's talked so far. Is a Republican Congress, even if it's one, maybe the Senate will be Republican and maybe the House will be Democrat. Republican Senate's not really been in the business of passing new regulatory rules. The other thing is that the whole idea of federal preemption, preempting state law, is a lot trickier than people have realized. So the Chamber of Commerce proposal stressed flexibility, stressed the need to not have one size fits all. So it basically has some vague principles in line for privacy. But how are those vague principles at the federal level going to preempt very specific under 13-year-old children rules or other very specific rules at the California level? And so usually if you have a federal preemption, it's because the federal law is detailed. But industry is asking for the federal law to be vague. So it's not clear how they can have their cake and eat it too when it comes to industry. How can you have a vague law that preempts the specific state laws? That's going to be a tough thing. So my last slide, the summary is that the California law is on the books. There likely will be amendments next year. The overall effect will be modest, some changes, maybe all the way up to pretty big changes, and those changes will mostly be in the direction of more favorable to business activities. You can expect lots of new discussion of federal privacy laws, but I think that it's unlikely to pass anytime soon. So I think the most likely scenario, in summary, and then I'll turn it over to Jim, is that most of the California law is likely to go into effect and affect businesses, and we could very likely see other state laws as well. So this is not just a blip. This is likely to be a reality for businesses going forward. Thanks.
Thanks, Peter, for those insightful remarks, as always. we're going to do something a little bit different today and talk about the process before we get into the substance of the law. And the reason we're doing this is because, as everyone knows, the GDPR was effective on May 25th, and companies that struggled with the GDPR at kind of fundamental levels know all about that process. But what the questions that we're getting now are coming from companies that are largely domestic, did not, for whatever reason, struggle with the GDPR, and I think there's a lot to be learned from the process. So we wanted to present that to you first before you think about the law, or before we talk about the law, so that you can think about, okay, what process impact will that have in my organization? There are potentially quite significant, if not massive, business changes that could come out of this, depending on your business, the data you collect, with whom you share it, the business model, etc. So, and I think even if there aren't massive changes in your business, you do have to think about, well, we really have to do this. This is not just changing the privacy policy and implementing disclosure regarding do not track. There are a lot of business processes that will have to change as a result of this. So no shell compliance for a relatively sophisticated company, it just won't work. One of the first things that you will hear privacy professionals talk about is the necessity and importance of data mapping and an inventory of your data. For years in the cyber scenario, in the breach scenario, I've encouraged people to go back and talk to their security organization and say, do you have a network map? And largely speaking, everyone goes back and talks to the organization, and a network map is actually harder than one might expect. Well, if you ask the same question of the relevant individuals about a data map or an inventory of where data comes from, how it moves throughout the organization, all of the applications and databases in which it resides, and then with whom you share it and for what purpose, and who has the levers and pushes the buttons with respect to all of those issues, that's a very complex thing. But to the extent that significant changes are required in your business process, I think it will be difficult to impossible to just put a Band-Aid on top of the organization and say, okay, we're going to track the specific piece of information that was sold regarding John Doe or Susan Smith, via a spreadsheet or in some ad hoc manner. It will take a lot of work. The other thing that we discovered early on, 3 or 4 years ago in the GDPR implementation process, was that you have to have a lot of people sitting at the table. It is not just a legal exercise. It's not just a compliance exercise. In order to change all of those IT systems and, in fact, potentially change the business, you need people from IT, you need people from security, you need people from the privacy office, perhaps marketing, or whatever the case may be. So if you go into a room and there are just a bunch of lawyers sitting there, I mean, there obviously will be some value in that, but ultimately the team is going to have to be much wider and across the enterprise. We found in the GDPR that thinking about who was on that team was important. Is there one person or very few people with responsibility overall? That tends to make things happen. They probably will have their bonus tied to success and compliance with the CCPA or something like that. And late in the GDPR process, I got the question twice. Are we compliant with the GDPR? And when you dug into it, it was because that person's bonus relied on them being able to report to the board or someone that they were compliant. So think about what success means. As we all know, there will be some risk-based decision-making in this process, and think about that. Importantly, also, think about who's going to pay for all this. Early on in the GDPR process, there was a lot of finger-pointing of, well, this ought to come out of the legal's budget, this ought to come out of IT's budget, no, this ought to come out of marketing's budget, whatever the case may be. And we found in 2016, companies at stasis because of these budget issues. And this came up in the middle of this year, so likely there's not money sitting around in budgets to make it happen this year. But as you can see from the comments, we really need to move quickly. The external team is also important. There are a number of software and compliance solutions out there. Those also can't be just a paper exercise. You probably have an existing compliance program, depending on the company. You may have an existing compliance solution, and how does this fit in with that? And, oh, by the way, it's not just procuring the software or the SaaS platform or whatever the case may be. It's actually got to be implemented and used in a valuable way. And there'll be consultants, hot and cold consultants running in every direction on this, I think out of necessity because of the expertise they bring to the table and the lack of bandwidth that we will run into. But do you have the right consultant? Who's managing that consultant, et cetera? And then third parties and service providers. In the GDPR, I don't think there is the requirement of a per se data processing agreement as we found under the GDPR, but there will be a lot of activities with third parties and service providers, much of which is beyond your control. Allocate, 2 times what you currently think it'll take to get all the way through that process. You pay them money if you are the customer. So you would think that gives you leverage, but in the GDPR we found that there were certain instances where that leverage just wasn't the case. So we offer these process points at the beginning so that you can sort of saturate your thinking about the statute, which David Keating is now going to talk about.
Great. Thanks, Tim. I'm going to take us through a review of the scope of the CCPA. I'm going to hit some of the highlights of the core requirements of the statute, and given our limited time, focus on what we are seeing as key points and nuances that we think are material to businesses as you're planning readiness programs. We mentioned at the outset that we will have further programs to drill down into specific issues. You can also drop questions, as you mentioned at the beginning, in the Q&A box. If we don't get to them during this program, we'll work to follow up after the program, and then, of course, we're all available to discuss any specific questions as well. The statute applies to businesses that are doing business in the state of California that collect personal information relating to California residents. The statute excludes nonprofits, but there's specific statutory language that defines the scope of that exclusion. If you're going to rely on it, you should review that language, ensure alignment with what the statute directly says. Keep in mind, too, that a transfer of personal information to a nonprofit will still be covered by the statute. There is a revenue threshold for businesses that's pretty modest. The statute also has alternative qualification criteria, so you can have a small startup that is data-driven, data-dependent, that finds itself covered by the law. The one of a number of unique features, we might say, of the statute is that it's called the Consumer Privacy Act, but it doesn't just apply to consumers. Any resident of California is in scope. The law applies to your employees in California, contractors, job applicants, and others. The statute defines personal information in a way that, at first glance, looks consistent with how we think of the term from a consumer privacy perspective, but there are some differences. The statute provides a non-exclusive list of categories of examples. We read that list to be dependent on those categories of information being identifiable or linkable to an individual. The definition also talks about a household, and that appears to be taking direct aim at the marketing and advertising industry with segments built around households. Another point in the statutory text that is potentially a challenge is that it talks in terms of information that relates to a particular consumer or household. Now, we're used to seeing in the traditional definition information that identifies or relates to an identifiable individual. Relate to is used, but it's connected with identifiability. Here, there's some question about whether the statutory definition goes beyond information that's related to an identifiable individual. We don't think that's the right interpretation. But the way it's drafted leaves a question, and if that's the case, then do we have some overlap potentially with de-identified information? The Venn diagram here is intended to depict the distinction between the broad set of de-identified information, which can be individually identifiable, and the subset of de-identified data that can be aggregated. Both concepts are defined in the statute. Both are excluded. De-identified information, though, has certain conditions attached to the definition. If you don't meet these conditions, potentially including downstream contractual requirements of service providers, the question is whether that information then falls back into the category of personal information. There are exceptions to the law's coverage as we look at interplay, in particular with federal law. Healthcare providers, covered entities, health plans are exempted to the extent they are using PHI or CMIA medical information. An interesting feature of the Labor Day Amendment that is still awaiting signature or will, I think it's after 30 days, become law if not signed, is that this exemption is extended to other patient information that a covered entity maintains consistent with HIPAA. So that makes me think about like a digital presence where a provider or health plan might have digital app engagement with patients. You have non-PHI information. Thought should go into whether treating and aligning that information with your HIPAA compliance program is of value because it arguably takes the information outside the scope of the CCPA. The statute excludes information that would be included in consumer reports to consumer reporting agencies regulated by the FCRA. That also has some interesting digital applications as we think about things like, and this comes up, I think, as you're looking at cataloging data sharing arrangements. One thing that we need to do under the CCPA to evaluate those arrangements as sales or non-sales. Here, as we look at those arrangements and think about like engagements with fraud detection providers, identity verification providers, and e-commerce, potentially that data might fall under this exemption, requires additional analysis. The law, as signed in June, had an exemption that's not an exemption for financial institutions as to non-public personal information under the Gramm-Leach-Bliley Act. The statute says, as it's written today, that doesn't apply to that information to the extent there's a conflict between the CCPA and Gramm-Leach-Bliley. In our analysis, we have not identified conflicts. The amendment, as proposed, extends that exemption to financial institutions to the extent they're using non-public personal information pursuant to GLB. The words pursuant to here are meaningful. The healthcare exemption says if they're using PHI, it's out. It's not covered for a covered entity. The GLB exemption says if they're using non-public personal information pursuant to GLB. So if, like we, for example, don't follow the safeguards rule under Gramm-Leach to the letter, then does that mean we're not subject to the exemption? And what does it mean to say that we're using non-public personal information pursuant to GLB anyway? It's just not entirely clear and requires some further thought. The statute, as enacted, went beyond the original ballot initiative, which was focused on the cornerstone of do not sell, to create new rights, a right of information or transparency, a right of access to personal information, a right to receive personal information in a portable format, tightly integrated with that right of access, and a right to deletion. Consumers have a right to request personal information or request information about the personal information that businesses are collecting about them. As we're thinking through starting to build our compliance models, pay particular attention to the last bullet, which talks about having to identify the specific pieces of personal information that you've collected about the consumer. That's challenging. We have clients that are rationalizing this to a degree. If you do pursue that approach strictly to have a very subjective response, individualized, which is seemingly what the letter of the statute might say we need to do, then have we also done what's necessary essentially to put together the data we'd need in the event of an access request? Kind of interesting interplay here. Consumers have a right also to request information about personal information that a company sold or used for a business purpose. A particular point here is in the third bullet point. I guess it's the second sub-bullet point, which talks about linking the categories of personal information to each third party to which the information was disclosed. Not clear if that means individualized, like I sold it to Acme Corp, or categorized. We think the latter seems to be more the intent here. It's just not clear. Consumers have a right to request access to information, personal information, that a business has collected about them. This goes beyond information that the business has collected from the consumer. It's any information that a company has collected about the consumer from any source. The consumer has a right to access to that information. We must, and this is integrated with a right to data portability. We must respond if we have an online or digital account, some form of an account with the consumer. We must respond through that account to the request. And if we respond through that account, it must be an electronic response. And if we respond electronically, the response must be portable. The way we read that is there's some guidance in the statute, and we also read it consistent generally with the GDPR approach to mean that the data must be machine readable in a commercially available format that could be uploaded to, say, a competing service. That maybe sounds a bit less like privacy, more like competition law, more that's an ongoing discussion. If you don't have an account that's online with the consumer, then you can provide the information back either by mail or electronically, but that's at the election of the consumer. If they elect electronically, again, it must be portable. If they elect by mail and we have lots of requests, that's pretty burdensome. Consumers have a right to request deletion of personal information that we've collected from the consumer. This is limited to data that's been collected from the consumer. Unlike the right of access and the right of portability, there are specific exemptions to the right to deletion. So as we think and just go back for one moment to the right of access, we don't have an exemption for trade secrets. Nothing expressed in the statute about that. We have to think through, how do we address that issue? Right to deletion, we have specified exemptions. I've put a list together here, paraphrased somewhat. A few things to call out. One is the fourth bullet point in the left column, exercise of another right provided for by law. Does that cover trade secrets? Is that really applicable here? In the right column, then we have concepts of compatibility with the original purpose. That sounds very EU-like, very GDPR-like. We also have an exemption for uses that are reasonably aligned with the consumer's expectations. The upshot there is another reason for us to be focusing on level of clarity in drafting and simplicity and conspicuousness in our privacy policies, because that helps set, arguably, the expectation of the consumer. So let's talk for a few minutes about procedures for responding to rights requests from consumers. We need to have two channels to receive requests. One must be a good old-fashioned toll-free telephone number. Then if we have a website, we need to allow for requests to be received through the website. We must respond within 45 days. Interestingly, identity verification does not toll the response period. So if we need additional information in order for a request to qualify as a verifiable customer request, that doesn't toll the 45 days. If it takes 7 days, 14 days, you're subtracting digits. I mentioned you can extend your response once, though. Interestingly here, we apparently have two different extension periods. So in subsection 130A2, we are granted a one-time 45-day extension. If we meet a certain threshold, it's like reasonable necessity, something of that nature. 45 days. In subsection 145G1, we're granted a one-time 90-day extension, which must be notified to the requester within the original 45 days. So start to ask questions. Does that mean we have 45 plus 45 plus 90, 45 plus 90, 45 plus 45? Conservative approach would certainly say 45 plus 45, but we'd also say don't extend unless there's a compelling need that we can document, because otherwise we're at risk of being deemed in violation, and whether we need that extension will potentially be a question of fact. We just don't want to be arguing that point. The statute does not define for us the period of time in which to delete personal information, doesn't specify it. And then I think we've talked about, a question there is, what does that mean? Like, I almost would rather have 30 days or 45 days to delete it. I almost like that better than an unspecified time where someone says it took 6 days and it's too long. So not clear. And I think we've spoken about the delivery method. A few points on general limitations that we have that apply, including to access requests. The statute states shall not restrict the business's ability to comply with law, exercise or defend legal claims. That sounds very EU-like too. No violation of a privilege is required, because when we first looked at this, we thought that was interesting. Could litigants, for example, submit requests and required disclosure of privileged materials? And fortunately, that is not the case. The right to opt out from data sales, cornerstone of the original ballot initiative. Consumers have a right to opt out from sales of data. Sales are defined broadly. Consumers subsequently may authorize the sale of personal information. We'll talk in a few moments about financial incentive programs. One open question is, how does subsequent authorization tie into the non-discrimination and financial incentive program provisions in the statute? A sale is defined to include effectively data sharings for consideration. And my contracts professor used to tell us, if you want to find the consideration in the transaction, you just ask the parties why they're doing the deal. It's broad. Could be a payment of money. It could be that they wouldn't do the deal unless I gave them the data and I needed the service. It could be, very broad set. So what we need to do then is inventory data sharing arrangements, match them against the criteria, and do it carefully, because we have disclosure requirements that are built around this, as well as rights fulfillment in terms of enabling consumers to opt out. There are certain exceptions. There's an exception, as we'd expect, for transfers to service providers for a business purpose, but there are certain conditions attached to that exception. We do have certain things that we are supposed to have in contracts with vendors to fit within the service provider business purpose exception to a data sale. What if we don't have those things? Does that mean it's now a data sale? Is that how we need to read the statute? Or is it something else? On our websites, we must have words that say, do not sell my personal information, associated with a hypertext link or some other form of technology that sends us to a site or page or screen that enables consumers to opt out from data sales. We need to wait 12 months at least before we can ask for authorization again to sell personal information. Minors, though, it's not opt-out for data sales, it's opt-in. And the statute addresses minors in an interesting way, another sort of unique feature. In one place, the statute says that sales of personal information about a minor require consent. Then in subsection 120D, there's language that says a sale of personal information about a consumer less than 16 years old requires affirmative authorization. So is that different from consent? if you're 17, it's going to be implied consent, but if you're 15, it's affirmative authorization. We're not entirely sure. If you're between 16 and 13, the consumer can consent. We assume that also applies to 17-year-olds and 16-year-olds, although the statute's silent. And if you're under 13, affirmative authorization is required from the parent, but we don't know about 13-year-olds because they're not between 16 and 13, and we just need to make a risk decision about how best to handle 13-year-olds. There's some semi-lack of alignment with copper processes, so that could actually be somewhat challenging. We then have language that talks about willfully disregarding the consumer's age. As we think about interpreting that requirement, I do think it's helpful to look at COPPA standards around actual knowledge. There's one example of enabling back buttoning. For example, we have on our social media new app, we have something that says you put in your age, and someone puts in their 11, block them. They can just go one screen back and then put in that they're 24. If we enable that and we don't use, for example, a cookie or some other mechanism to prevent that back buttoning, that willful disregarding. I think the COPPA standards help. Non-discrimination and financial incentives merit much more than one slide and a few minutes. This might be an area where we follow up with a separate program as well. A dense part of the statute, so if a customer opts out, if a customer exercises some other right under the CCPA, we cannot discriminate against the customer based on that exercise. We can't refuse access, charge different prices, offer different levels of quality, but we actually can, as long as we have a financial incentive program. The standard for a financial incentive program, it's dictated in the statute, but in a way that is, again, challenging. The incentive, whether it's like a monetary payment or some different level in service, must be directly related or reasonably related to the value provided to the consumer by the consumer's data. One code section says it must be directly related, another says it must be reasonably related. But in either case, it must be related to the value provided to the consumer by the consumer's data. That's subjective. That seems to make it hard for us to establish standardized processes. We might, as in other areas, we might have guidance coming from the Attorney General's office that helps with this. But right now we have this subjective standard. And what does it mean? Like, what's the value that is provided to you by your data? Some consumers might say it's priceless. Like, you can't pay me enough. Another might say it's worth, 5 cents because I want to play Farmville or Fortnite. Who knows? If we get it wrong, then we have an enforcement risk. So just not right now a great area within the statute. We hope to see this built out some more. Financial incentives require prior opt-in consent. But what about if I just have good old, opt-in consent? Do I need a financial incentive associated with that too? We think not. Statutes maybe not entirely clear. Last thing I want to mention quickly is with website and privacy notice disclosure requirements. We have specific things that we need to put into our website privacy policy. In addition, any disclosure we have of California privacy rights. Pay attention to the specific mobile app requirements because they're specific. And then what about privacy disclosures to employees? In the U.S., many companies do not have employee privacy statements. Employees are covered by the California Consumer Privacy Act. We must make privacy disclosures to consumers, which include employees, under the CCPA. Those must be on our website. Do we need to create and put employee privacy policies on our websites? We're not sure. With that, turn it over to Jim.
Thanks very much, David. I'm going to talk about service providers and third parties and drill down on some of the things that David mentioned in his remarks. One thing is we want to know when a sale is occurring and when it is not occurring so that you can properly deal with opt-out requests and access requests, etc. There is an incredibly broad definition of sale within the statute, as David said, essentially something in sharing of data in return for value. And one might imagine any number of circumstances, surprising circumstances, where a sale would occur. The statute, though, does give us a little bit of relief because it says that no sale occurs when the business uses or shares data with a service provider, personal information of a consumer, if both, and there are two requirements to this, you had to have adjusted your terms and conditions as required by 135 of the statute, and I put in here murky statutory language because that's the way it's written in the statute. And then there are two other prongs. It must be a service provider, but the service provider must not further collect, sell, or use the PI of the consumer except as necessary to perform the business purpose. And both service provider and business purpose are defined under the statute. Hang on one second. There we go. So a service provider is a for-profit entity that processes information on behalf of a business to which the business discloses information for a business purpose pursuant to a written contract. So I can't tell you how many times over the years I've talked to clients about, and David and Peter have talked to clients about information sharing that's going on, often in marketing relationships, and there is no written contract. Well, in order to make sure that that's not a sale, all those things need to be reduced to a written contract. But it also has to be in connection with the business purpose, and that business purpose is restricted by the statute as one that is reasonably necessary and proportionate, and those words will ring true in a way to many that dealt with the GDPR, but the business purpose must be reasonably necessary and proportionate to achieve the operational purpose for which the information was collected, or for another purpose that is compatible with the context in which the personal information was collected. So I think if you look at your community of service provider relationships, you could say, well, probably 95% we have a written contract for. We know that we have restricted them to only using the data in connection or as required to fulfill the services acquired under the agreement. But then there's that 5% that may fall into this exception. Is what they're doing reasonably necessary and proportionate? A lot of the platform relationships that are happening, there is a trade of personal data in connection with the services. Pay a lot of attention to that. And then more on third parties. So in order to be if you're not a third party, which is important, if you have a written contract, you fulfilled the statutory requirements, which are set forth here, and there's a certification required. So the contract must include a certification made by the recipient that the person understands the restrictions and will comply with them. So certainly everyone that just went through the DPA and controller processor process under the GDPR has done a lot of work on their vendor contracts, but I doubt that many of us included a certification by the recipient that they understand the restrictions and will comply with them. But it's also important to note that if you disclose information to a third party in a compliant manner, that you are not liable if the recipient uses that information in violation of the CCPA, so long as you didn't have actual knowledge or reason to believe that the person intends to commit a violation. And that should be pretty easy, again, in 95% of the circumstances. But if you think someone's getting close to the edge, or if you are doing due diligence on a vendor and you're not convinced of their compliance with the contract or the CCPA provisions within the contract, does that create a reason to believe that the person intends to commit a violation? So there is a fair bit of a safe harbor there, if you will. On the other hand, there's also a cautionary note, and be sure and get this certification, get ready for the battle of the forms. So, for service providers and third parties, there are relatively complex provisions regarding the sale, which is a key kind of fulcrum definition within the statute, and what it takes to be a service provider and a third party. You need to be sure that your intended service providers, first of all, that you know who they are, that they're pursuant to a written contract, that the requirements of the statute are met within that contract, and that these magic words, reasonably necessary and proportionate to achieve the operational purpose, are found somewhere within that contract. There is a liability exclusion, but it does require this certification of understanding and no actual knowledge. Just to put a zinger in there, the statute, though, includes a statement that courts are directed to disregard a series of steps or transactions that are component parts of a single transaction intended to avoid the reach of this title, including the disclosure of information by a business to a third party in order to avoid the definition of sell. So they're paying a lot of attention in the statute, and, you know, David referred to his contracts professor. My mentor said, in general, you can't do indirectly what you can't do directly. And I think he was right about that, and they've codified that in the CCPA. So get ready for the battle of the forms. This will be hotly debated, and our vendor management department will talk to your vendor management department. So data breach. This is where a lot of the action is. There is a new private right of action. It relates to information that does not have the same definition of personal information as set forth under the CCPA. It's also not the same definition in the California Breach Notification Statute. So 781.5 is the statutory reference. Be sure and look at that when you're thinking about this private right of action. But any consumer whose unencrypted data is subject to unauthorized access and exfiltration, theft, or disclosure as a result of the business's violation of the duty to implement and maintain reasonable security procedures. For those of you that work in the data breach space, the standard of unauthorized access and exfiltration, theft, or disclosure, that's actually a pretty good standard. When I read that, there was a sigh of relief. But if you find yourself subject to one of these actions, the plaintiffs have the ability to recover damages statutory damages between $100 and $750 per consumer per incident, or actual damages, whichever is greater. They can also seek injunctive relief, and importantly, the court, in assessing statutory damages, you see the list of things that the court can consider, but one of the things that they can consider is assets, liabilities, and net worth. So if you thought you would get away on our technical violation and equities wouldn't enter into this conversation, think again. Plaintiffs must provide 30 days notice to the defendant and an opportunity to cure. I think there's a significant question of whether a data breach could be cured. Perhaps the circumstance underlying the data breach could be cured, but look for more, probably litigation, and hopefully guidance from the AG on that. No notice is required for individual actions for actual pecuniary damages only. So they still have the ability to haul you in small claims court without notice. We're seeing a lot of these small claims court actions in the data breach context. The August 31 amendments eliminated what I thought was a relatively odd obligation to notify the Attorney General and allow them to prosecute the action, and clarified that the cause of action created by the section doesn't create any other private right of action. We're going to come back to that. The Attorney General may also bring an action for up to $2,500 for each violation of the CCPA, and if there's an intentional violation, that goes up to $7,500. So you have the statutory damages, you have risk from an AG action. And then I think finally, I think there is still an open question about whether you have risk from the unfair competition law, widely known as 17200. As Peter mentioned, a lot of attention is being given to this. We have an advisory that was released earlier today, written by Bo Phillips and one of the folks in our LA office. Bo is a class action litigator in California and is spending a lot of time thinking about this. But CCPA says that nothing in this act shall be interpreted to serve as the basis for a private right of action under any other law. That sounds pretty good. But then when you look at the law behind 17200, it permits any person who has, including persons acting on behalf of themselves or its members, so class actions, to initiate an action for restitutionary or injunctive relief if they have engaged in any unlawful, unfair, or fraudulent business practice act or unfair, deceptive, untrue, or misleading advertising. It's been called sweeping by California courts, so 17200 has been called sweeping. And I think there's an open question. If you look at that statutory language, you would say, on the one hand, yes, there was a clear statutory intent to bar actions under 17200. Could it be written much more tightly and precisely? Absolutely. It could be written much more tightly and precisely, and we'll hope for that in some of the amendments. So if you think about this and think hard about your current insurance levels, the data breach statutory damages is an absolute game changer. If you have 100,000 records that trigger this statute, you could have up to $75 million in statutory damages under a private right of action, up to $250 million at risk via the AG. And then what about a 17200 action? Obviously, there's a lot of damages concepts that would come into play there, but our class action litigators in the data breach space think that the world just changed. There's a lot more at risk now, and I would urge you to talk to your risk management department, your insurance broker, of do you have enough of the right insurance to help you. And finally, there's been some talk of the operative date. It is operative as of January 1, 2020. There is some talk of pushing that back. Who knows whether that will in fact be the case. We already got some relief by the August amendments prohibiting AG enforcement until July 1, 2020, or 6 months after the publication of final regulations. Also note that there are extensive regulations to be issued by the California AG by mid-2020. And I think that will be helpful. Interestingly, the AG did write a letter to the legislature. I found it to be a remarkable letter, talking about various provisions within the statute, et cetera. So, but do look for AG guidance. Statute is very sort of AG intensive in the manner in which it incorporates the AG into the entire process. If you're in New York, if you are looking for CLE credit in New York, the code is AB032382. AB032382. We are almost at the end of the hour, but I'm going to try and distill several of the questions that we've received for Peter and David. One is, do we think that there will be relief on the employee side? I know, Peter, you've been talking to people involved in the fray. After all, they did name it the Consumer Privacy Act. What's this with employees?
Well, so what I've heard is that came up this year during the negotiations, and the legislature clearly kept employees on the inside. So it would be a big change from what the debate was this year to exempt employees next year. Doesn't mean it can't happen, but it would be a big change from what the legislature thought it was buying into.
Okay. Here's one for you, David. I like this question. Other than data mapping, what would you say are the top 3 action items a business affected by this must do? Is there a list of what must be mapped?
So, two questions. I know we're at the end of our time, so I want to respond quickly. We can also follow up. The vendor contracting piece, just because of the timeline that will likely be necessary, is one to start to address quickly, to identify potential in-scope vendors and gap assess existing privacy contractual terms against what California requires. And we have to make an assessment of, what do we do? Do we do another GPA death march, or do we try to approach this differently? That's one. Another, which is a smaller bite, is to review existing privacy disclosures and gap assess to determine what changes need to be made going forward. Then third is, you mentioned, in addition to data mapping, cataloging data sharing arrangements. So that may be kind of appended to a data mapping exercise, but I think it's different too. I think it goes to different functions internally, and that's clearly a measure that is going to be of high importance. Number of other things, but those come to mind.
Yeah. Sorry we couldn't get to the other questions. We're going to catalog those and may follow up with some of you individually. And I think we'll have a roadmap to the CCPA series, but stay tuned. We wanted to cover as much of the landscape today as possible, and we appreciate all of your attendance and participation.
Thank you.
That does conclude today's call. We thank everyone again for their participation.